This appeal concerns the validity of a will. Section 9 of the Wills Act, 1837, Section 9, contains certain formal requirements which have to be satisfied if a will is to be valid, including that the will is signed by the testator and that it appears that the testator intended the signature to give effect to the will. Section 20 of the Administration of Justice Act 1982, Section 20, empowers the court to rectify or correct a will in limited circumstances, including where the mistake is due to what is called a clerical error. In 1999, Mr and Mrs Rawlings were visited by their solicitor to execute their wills. They were in effectively identical form. They each left their entire estate to the other, but if the other had already died, it was left to a Mr Marley. By mistake, the solicitor gave each of them the other's draft will, and each signed the will meant for the other. Mr Rawlings died in 2003. Mrs Rawlings died, I beg your pardon, in 2003, and nobody noticed the error. It came to light when Mr Rawlings died in 2006. Mr and Mrs Rawlings' two sons challenged the validity of the will which Mr Rawlings had signed, the will. If it was valid, Mr Marley would inherit Mr Rawlings' estate. If it was invalid, Mr Rawlings would have died intestate, and the two sons would have inherited the estate. Mr Marley began probate proceedings. The judge dismissed his claim, holding that the will was not effective, first because it didn't satisfy the requirements, the formal requirements of Section 9, and secondly, even if it had done so, she could not rectify the will under Section 20 because the error was not a clerical error. Mr Marley appealed to the Court of Appeal, who upheld the decision on the first ground, the will didn't comply with the formalities, and therefore decided it need not consider the second ground. The Supreme Court unanimously allows Mr Marley's appeal for reasons given in a judgment which I've written. The will should be rectified so that it contains the typed parts of the will signed by the late Mrs Rawlings in place of the typed parts of the will signed by Mr Rawlings. When interpreting a will, the court adopts the same approach as it does to the interpretation of contracts, notices and patents, subject to any statutory provision to the contrary, a view confirmed by Section 21 of the Administration of Justice Act 1982. Mr Marley's case rested on three contentions. One, that the will should be read as if it was the document which had actually been signed by Mrs Rawlings. Two, that the will should be validated by making certain deletions from it. Or three, the will should be rectified so that it accords with Mr Rawlings' intentions. So far as interpretation is concerned, whether a particular approach to interpreting a will is one strictly of interpretation or rectification is an important and sometimes a rather difficult and controversial issue, and we heard only limited argument on the point. As the appeal can succeed on the grounds of rectification, we consider it safer to assume, for the purpose of our judgment, that it fails on interpretation. Second ground, deletions. We reject Mr Marley's contention that the will can be validated by reference to the power which the court has, in some circumstances, to make deletions from a will in order to make it valid. It's inappropriate to invoke this principle to justify selecting passages and provisions for deletion from a will clearly intended to be signed by somebody else, to enable the will, almost by happenstance, to comply with the testator's intentions. Third ground, rectification. The will is unambiguously intended to be Mr Rawlings' formal will, as he signed it, and he clearly intended it should have effect as his will. The fact that it may face problems in terms of interpretation or even validity does not mean that it cannot satisfy the formal requirements of Section 9. In any event, even if it did not satisfy the formal requirements of Section 9, a document doesn't have to satisfy those requirements before it can be treated as a will capable of rectified pursuant to Section 20. It's enough that the document concerned was clearly intended to be a will. So far as the claim for rectification itself is concerned, the words clerical error in Section 20 should carry the wider meaning of a mistake arising out of office work of a relatively routine nature, such as preparing, filing, or sending or organizing the execution of a document, rather than the narrower meaning of a failure in transcription. Consequently, the will falls within section 20 and can be rectified under that section. Lord Hodge, in a brief concurring judgment, sees no reason in principle why under Scottish law the partial reduction and declarator should not be available to cure defective expression in a will.